A bipartisan group of 35 former judges filing a striking brief calling for an investigation into that settlement that led to the creation of President Trump's $1.8 billion, what he calls the anti-weaponization fund. The deal was struck in exchange for Trump dropping his lawsuit against the IRS. It also grants him, his family, and businesses immunity from ongoing inquiries into their taxes. It calls the settlement a product of collusion and is itself a fraud on the court. With me now, one of the judges who filed that brief, Shira Scheindlin, retired U.S. District Judge in the Southern District of New York. There has been a lot of hue and cry about this deal. Tell us why it was important for all of you to get together and write this.
We thought it was very important because the court plays a role in our government, and it shouldn't be used as a way of doing something that otherwise couldn't be done. And so the court was really...
Hello, guys. Welcome. Dr. John is here. So this is happening, Reith. Now, Chief Justice John Roberts has issued a rare public rebuke of President Trump for threatening to impeach Judge James Boasberg, who blocked Trump's deportation order invoking an 18th century law. Roberts warned that Trump's behavior is incompatible with 200 years of constitutional practice and threatens the separation of powers, marking an unprecedented clash between the executive and judicial branches. Trump's reaction to Judge Boasberg's ruling was immediate, explosive, and entirely predictable for anyone who has watched his behavior over the years. He took to Truth Social and unleashed a torrent of personal attacks against the judge, calling him a troublemaker and an agitator who didn't understand the law, lumping him in with what Trump called crooked judges who were trying to obstruct his agenda. But then Trump went far beyond the usual personal attacks and did something that shocked.
Used, so to speak. There was a fraud on the court. Because this was a collusive lawsuit, there may not have been a real case and controversy because President Trump was on both sides of the case, right? He's the president and he's suing his own agency, which he basically controls. So it was a way of making a deal that would then support this anti-weaponization fund and his own immunity, which was never disclosed to the court. So when you have a fraud on the court, former judges care about that.
So when you short circuit essentially a judge's ability to examine settlement terms, obvious question is, how do you even do that?
Well, that's not exactly what was short circuited.
Okay, tell us.
It wasn't the settlement terms. What was really short circuited is whether there was a really honest case or controversy. If there was no case, then the court had no jurisdiction, and you couldn't settle a case that doesn't belong in the court.
The legal community, and prompted Chief Justice Roberts to speak out. Trump called for the judge to be impeached, writing on social media that the judge should be impeached, using exclamation points to emphasize his demand for Congress to remove a federal judge simply because the judge had ruled against him in a case. The constitutional significance of Trump's impeachment threat cannot be overstated because it represents a fundamental attack on the independence of the judiciary that has no precedent in modern American history. Impeachment was designed by the founders as a check on the executive branch, a tool for removing presidents and other officials who committed serious misconduct like treason, bribery, or high crimes and misdemeanors. Impeachment was never intended to be used against judges for their judicial decisions, because using impeachment as a weapon to punish judges who rule against the president would completely undermine judicial independence.
So you take away the underpinning of the entire so-called settlement, which is based on that case. It even uses the caption. It says, this case was filed and now we're settling this case. 2 days later, she was to receive briefs. The judge was to receive briefs as to whether there was a real case or controversy. But by rushing into court on that day, on May 18th, she never saw those briefs. She never got a chance to rule. And we don't know if there was a real case or controversy.
And did she have any options?
Well, she didn't know about this settlement. She was just told this is a voluntary dismissal with prejudice. She didn't have any questions. She made a statement. She said, on the record, and there's no settlement on the record. So she assumed there was no settlement. They just were dropping the case. But that turned out to be a fraud because on that very same day, May 18th, the settlement agreement was signed. The document is signed by the then, I think, Deputy Attorney General Stanley Woodward signed that document on the same day. but nobody told the judge.
And transform the judiciary from a co-equal branch of government into a subordinate arm of the executive. The founders understood this, and for more than 2 centuries, no American president had ever threatened to impeach a judge simply because they disagreed with a ruling. Chief Justice Roberts' decision to issue a public statement rebuking Trump was itself an extraordinary event, because Roberts is famously cautious about commenting on political controversies and has been criticized by legal scholars for being too restrained in defending the judiciary from political attacks. But in this moment, Roberts determined that the threat to judicial independence was so serious that he could not remain silent, and his statement was direct, unambiguous, and devastating in its constitutional clarity. Roberts said that for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision.
So she didn't know that they were going around her to figure out whether there was a real case or controversy and whether there was a settlement. Because she even said, there's no settlement.
So realistically, can anything be done about this now?
Oh, yes. There's a rule, Federal Rule of Civil Procedure 60, that would allow her to reopen this case because a voluntary dismissal with prejudice is a final judgment. So she can reopen this case either on the motion of one of us, the 35 judges, or on her own. It's called sua sponte, which means on her own motion. She can reopen the case and she can examine now, conduct an inquiry. Was there ever really a case or controversy? And let me explain what I mean by that. When a similar case was brought by other plaintiffs who said our tax returns were wrongfully disclosed, the government fought that and said, well, the guy who disclosed it wasn't even a government employee, and it's the same guy. It's a guy named Littlejohn. So they had defenses, plus it wasn't even timely. This case should have been time barred.
And he explained that the appellate process exists for that exact purpose, that if you disagree with a judge's ruling, you appeal it to a higher court. You make your legal arguments there. You don't threaten to impeach the judge because you're angry with the decision. The Chief Justice's statement was a reminder of the most fundamental principles of American constitutional government, that the judiciary is an independent branch of government, that judges are not supposed to be loyal to the president or any other political figure, and that judicial independence is essential to the rule of law and the protection of individual rights. Roberts was essentially telling Trump that if he continues down this path, if he continues threatening judges with impeachment for ruling against him.
So the government in the past has fought those kind of cases. This time, they just made this deal, which has these 2 prongs that you talked about, this terrible anti-weaponization fund of $1.776 billion and total immunity for Trump and his family for everything done up to the day of the settlement. But there can't be a settlement if there's no case.
When you look at this and well beyond this case, what's your observation about the pressure and the changes that the President of the United States is essentially forcing on the judiciary these days?
Mm-hmm. Well, you say forcing. I think the judiciary, certainly in the lower courts, the trial courts, and the circuit courts, has been the guardrails, has stopped many of the things that the president has tried to do to sort of get around the judiciary or neuter the judiciary.
Yeah, by forcing, I meant they're looking at things that they've never really
Well, that is certainly true. But for example, as you know, they stopped his tariff decision.
He will destroy the entire system of checks and balances that has held the country together for centuries. He was warning that the behavior Trump is engaged in, the threats he is making, the attacks on judges, these are the kinds of things that undermine the foundation of democracy itself. The broader pattern of Trump's attacks on the judiciary makes Chief Justice Roberts' intervention even more significant, because this is not an isolated incident, but part of a systematic effort to intimidate and delegitimize the courts. Trump has repeatedly called for judges to be impeached when they have ruled against him. He has attacked judges personally with vitriolic language. He has called them crooked and incompetent. He has questioned their intelligence and their judicial reasoning. And he has created an environment where judges and their families face credible threats of violence. There have been bomb scares at the homes of federal judges who ruled against Trump. There have been armed protests outside courthouses, and Trump has not condemned this violence, but has amplified the attacks and given his supporters an implicit green light to continue their intimidation campaign. The constitutional law surrounding impeachment adds another dimension to this crisis, because Trump has previously suggested that if Congress ever tries to impeach him again, he will go to the Supreme Court to stop it. This reveals a fundamental misunderstanding of how impeachment works in the American constitutional system, because the Constitution gives the House the sole power of impeachment and the Senate the sole power to try and convict someone who has been impeached, with absolutely no role for courts in the process. The Supreme Court itself held unanimously in a 1993 case that courts have no jurisdiction over impeachment decisions, that the judiciary cannot stop an impeachment, that the courts cannot review impeachment decisions, and that Congress has complete and exclusive control over impeachment. So if Trump thinks he can run to his allies on the Supreme Court to save him from impeachment, he is fundamentally misunderstanding the Constitution and how the separation of powers works. The irony of Trump's impeachment threats is that the behavior he is engaging in, threatening judges for their rulings, attacking the independence of the judiciary, and trying to use the power of government to intimidate judges into ruling his way, is itself the kind of conduct that could justify impeachment. The founders designed impeachment to protect the Constitution from presidents who abuse their power and attack the foundations of the constitutional system. And Trump's assault on judicial independence is precisely the kind of abuse that the impeachment power was meant to address. Chief Justice Roberts was implicitly raising this point when he reminded everyone that impeachment is a serious power that should not be used lightly but is reserved for the most serious constitutional violations. The separation of powers principle that Roberts invoked is one of the most fundamental features of American constitutional government, and it is the principle that Trump is most directly threatening with his impeachment threats. The founders understood that concentrated power is dangerous, and that the only way to protect liberty is to divide power among different branches of government that could check each other. The judiciary was designed to be independent from the executive so that judges could rule on cases based on the law and the Constitution, not based on loyalty to the president or fear of political retaliation. When a president threatens judges with impeachment for their rulings, he is directly attacking that independence and trying to subordinate the judiciary to the executive, which would destroy the entire system of checks and balances that protects American freedom. The response from the legal community to Chief Justice Roberts' statement has been overwhelmingly supportive, with legal scholars and former judges praising Roberts for speaking out and warning that the threat to judicial independence is more serious than at any time in modern American history. Many have noted that Roberts' statement was particularly significant because he is not known for intervening in political controversies, and his decision to break his silence suggests that he believes the situation has reached a critical point. The statement has been covered extensively by major news outlets, and it has prompted a serious national conversation about whether the constitutional system can survive a president who attacks the judiciary and whether the separation of powers can withstand the pressure that Trump is putting on it. The timing of Chief Justice Roberts' statement is also significant because it comes at a moment when Trump is facing multiple legal challenges to his policies and when his attacks on the judiciary are becoming more frequent and more extreme. Trump has been losing in court on numerous issues, from immigration to environmental regulation to presidential power, and each loss has been met with a new round of attacks on the judges who ruled against him. The pattern is clear and unmistakable. When Trump loses in court, he attacks the judge, he threatens impeachment, and he tries to delegitimize the ruling and the judge who issued it. This is not the behavior of someone who respects the rule of law. It is the behavior of someone who believes that courts should exist to serve him and that any judge who rules against him is an enemy to be destroyed. The historical context of Chief Justice Roberts' statement is important for understanding just how unprecedented and significant this moment is, because no Chief Justice in modern American history has ever issued a public rebuke of a president for threatening judges with impeachment. The relationship between the Supreme Court and the presidency has generally been one of mutual respect and institutional restraint, with the court deferring to the executive on matters of policy, and the executive accepting the court's rulings on constitutional questions. But Trump has shattered that norm, treating judges as enemies and the courts as obstacles to be overcome rather than co-equal branches to be respected. Roberts' statement represents an attempt to re-establish the boundaries that Trump has been eroding, to remind the president and the country that the judiciary is not subordinate to the executive and that judges are not subject to impeachment for doing their constitutional duty. The specific legal case that triggered Roberts' intervention involves the Alien Enemies Act of 1798, a law that Trump cited as authority for his mass deportation executive order. The law was originally enacted during a period of tension with France and gives the president authority to deport non-citizens from enemy nations during a declared war or invasion. Trump argued that the law gave him authority to deport alleged Venezuelan gang members without due process, but Judge Boasberg ruled that the law did not authorize the kind of mass deportation that Trump was attempting, and that the Constitution required proper due process before individuals could be deported. Judge Boasberg did exactly what the Constitution requires of judges. He interpreted the law and applied it to the case before him, and he ruled that the executive had exceeded its authority. Trump's response to Judge Boasberg's ruling was not to appeal the decision through the normal legal process, which would have been the appropriate and constitutional response, but to attack the judge personally and call for his impeachment. This response reveals Trump's fundamental misunderstanding of how the legal system works and his contempt for the rule of law, because appeals are the normal and appropriate way to challenge a judicial ruling that you believe is wrong. You don't impeach a judge because you disagree with his decision. You appeal to a higher court and make your legal arguments there. That's how the system works. That's how it's supposed to work. And that's what the Chief Justice was reminding everyone when he issued his statement. The appellate process that Roberts referenced is one of the most important features of the American legal system because it provides a mechanism for correcting errors and ensuring that the law is applied consistently and fairly. When a judge makes a ruling that a party believes is wrong, that party can appeal to a higher court, which will review the decision and determine whether the judge correctly interpreted the law. This process ensures that no single judge has final authority over the law and that legal errors can be corrected through a careful and deliberative process. Trump's attempt to bypass the appellate process and go directly to impeachment threats represents an attack on this foundational feature of the legal system, an attempt to substitute political intimidation for legal review. The broader pattern of Trump's attacks on the judiciary extends beyond impeachment threats to include personal attacks on judges, demands that the Justice Department prosecute his political enemies, and implicit encouragement of violence against judges and their families. There have been multiple bomb scares at the homes of federal judges who have ruled against Trump, and there have been credible threats against the families of judges who have issued rulings that Trump opposes. Trump has not condemned this violence, but has instead amplified the attacks, calling judges crooked and incompetent and suggesting that they are part of a conspiracy to obstruct his agenda. This is the behavior of someone who is trying to create a climate of fear in the judiciary, to make judges afraid to rule against him because they know they will face personal attacks and threats. The constitutional implications of Trump's behavior are profound, because if presidents can use impeachment threats to intimidate judges, the judiciary will no longer be independent, and the separation of powers will be destroyed. Judges will be afraid to rule against the president because they know they will face personal attacks, threats of violence, and the threat of impeachment. They will make decisions based on fear and political pressure rather than on the law and the Constitution, and the entire system of checks and balances will collapse. This is exactly the kind of constitutional crisis that the founders feared, and it is exactly what Chief Justice Roberts was warning against when he issued his statement. The legal community's response to Chief Justice Roberts' statement has been one of relief and gratitude, with many legal scholars noting that Roberts has finally taken a stand against the president's attacks on judicial independence. Some critics had previously argued that Roberts was too passive in defending the judiciary from Trump's attacks, that he was allowing the institution he leads to be undermined without speaking out, and that his silence was a form of complicity. But Roberts' statement has answered those criticisms, showing that he is willing to speak out when the threat to judicial independence becomes sufficiently serious, and that he understands the gravity of the moment. The statement has been seen as a turning point in the relationship between the judiciary and the executive, a moment when the Chief Justice drew a line that the president cannot cross. The connection between Trump's impeachment threats and his broader assault on democratic institutions is also significant, because Trump has not just attacked the judiciary, but has also attacked the free press, the intelligence community, the Justice Department, and the electoral process. He has called journalists enemies of the people. He has accused intelligence officials of treason. He has demanded that the Justice Department investigate his political opponents, and he has spread false claims of election fraud to undermine public confidence in the electoral system. The pattern is clear. Trump is systematically attacking every institution that can hold him accountable, trying to delegitimize and weaken them so that he can operate without constraint. The judiciary is just the latest institution to come under attack, but it is one of the most important because of its role in interpreting the Constitution and protecting individual rights. The question that Chief Justice Roberts' statement raises is whether the judicial branch can withstand this assault, or whether it will eventually be weakened to the point where it can no longer function as an independent check on executive power. The courts have so far continued to rule against Trump when the law requires it, issuing orders that have blocked many of his policies and required him to comply with legal requirements. But the cumulative effect of the attacks, the threats, and the intimidation is taking a toll, and there are concerns that judges may become more cautious in ruling against the president for fear of reprisals. Roberts' statement is an attempt to push back against that dynamic, to remind judges that they have the support of the Chief Justice and that they should not be intimidated by political attacks. The political implications of Roberts' statement are also significant because it puts pressure on congressional Republicans to respond to Trump's impeachment threats and to defend the judiciary from presidential attacks. Congressional Republicans have been largely silent in response to Trump's attacks on the judiciary, not wanting to break with the president or alienate his supporters. But Roberts' statement has changed the dynamic, making it harder for Republicans to remain silent and forcing them to take a position on whether they support the president's impeachment threats or the Chief Justice's defense of judicial independence. This is a test of whether congressional Republicans will defend the Constitution and the separation of powers, or whether they will continue to enable Trump's assault on democratic institutions. The possibility of actual impeachment of a federal judge is one of the most serious constitutional issues that has been raised by Trump's threats, because it would represent a fundamental break with 200 years of constitutional practice. No federal judge has ever been impeached for making a ruling that a president disagreed with, and the idea of using impeachment to punish judges for their decisions is deeply antithetical to American constitutional values. If Congress were to impeach a judge for ruling against Trump, it would send a signal that the judiciary is no longer independent, that judges can be removed for doing their constitutional duty, and that presidents can use impeachment to intimidate the courts. This is the outcome that Chief Justice Roberts is trying to prevent, and his statement is a warning to Congress that it should not cross that line. The ultimate significance of Chief Justice Roberts' statement lies in what it tells us about the state of American democracy and the capacity of constitutional institutions to withstand an assault from a president who does not respect constitutional limits on his power. For 250 years, the American constitutional system has relied on the assumption that presidents will respect the separation of powers, that they will accept judicial rulings even when they disagree, and that they will not try to intimidate or destroy the other branches of government. Trump has shattered that assumption, treating the courts as enemies to be conquered and the Constitution as an obstacle to be overcome. And Roberts' statement is an acknowledgement that the assumption can no longer be relied upon. The warning that Roberts is issuing is not just to Trump, but to the entire country, because the threat to judicial independence is not just a threat to the courts, but a threat to the entire constitutional order. If the judiciary is no longer independent, the rule of law will collapse, and individual rights will no longer be protected from government abuse. The courts are the last line of defense against executive overreach, the institution that can say no to a president who is trying to exceed his constitutional authority, and if that institution is weakened or intimidated, there will be no check on presidential power. This is the constitutional crisis that Roberts is warning about, and it is a crisis that could have catastrophic consequences for American democracy. The response to Roberts' statement from the political system will be a test of whether the system can defend itself against an executive who is attacking its foundations. Congress has the power to check presidential abuse, including the power of impeachment, and Roberts' statement is implicitly calling on Congress to use that power if Trump continues to attack the judiciary. But Congress has been reluctant to challenge Trump, with congressional Republicans in particular staying silent in the face of his attacks on democratic institutions. The question is whether Roberts' statement will change that dynamic, whether the Chief Justice's defense of judicial independence will prompt Congress to act, or whether the political system will continue to enable Trump's assault on constitutional governance. The broader historical significance of Roberts' statement is that it represents a moment of institutional resistance, a time when one branch of government pushed back against an executive who was trying to undermine its independence. Throughout American history, there have been moments when presidents have tried to expand their power at the expense of the other branches, and there have been moments when the other branches have pushed back. Roberts' statement is a reminder that the separation of powers is not a dead letter, that there are still officials who will defend their institutions against executive overreach, and that the constitutional system still has some capacity to resist the accumulation of power in the presidency. The implications for the future of the judiciary are also significant because Roberts' statement sets a precedent for how chief justices will respond to presidential attacks on the courts. Future presidents who might be tempted to follow Trump's example and threaten judges with impeachment will know that they will face public rebuke from the chief justice, that they cannot attack the courts without provoking a response from the leader of the judicial branch. This is an important deterrent effect, a signal that the judiciary will not remain silent in the face of presidential attacks and that there are consequences to threatening judicial independence. The legal doctrine that Roberts invoked, that impeachment is not an appropriate response to disagreement with a judicial decision, is not just a matter of tradition or custom, but is rooted in the Constitution's design. The founders understood that judicial independence was essential to the rule of law, and that allowing presidents to use impeachment to punish judges for their decisions would destroy that independence. They created a system where judges serve for life and can only be removed for serious misconduct, not for making unpopular decisions or decisions that presidents disagree with. Roberts' statement was a reminder of that constitutional design and a warning that Trump's impeachment threats are incompatible with it. The potential consequences of Trump's impeachment threats extend beyond the judiciary to the entire constitutional system because if one branch can be intimidated into submission, the others may follow. If the courts can be made to fear the president, if they can be forced to rule based on political pressure rather than the law, then the separation of powers is effectively dead and the president has become a monarch. This is not hyperbole or alarmism. This is the logical conclusion of a process that has been underway since Trump entered office, a process of systematically attacking and weakening every institution that can check his power. The courts are the last line of defense, and Roberts' statement is a recognition that if the courts fall, the constitutional order falls with them. The pressure that Trump is putting on the courts is unprecedented in its intensity and its relentlessness, with attacks coming not just from the president himself, but from his allies in Congress, his supporters in the media, and his followers on social media. Every time a court rules against Trump, there is a coordinated campaign of attacks designed to delegitimize the ruling and the judge who issued it, with Trump leading the charge and his supporters amplifying the message. This is not a spontaneous response to individual rulings, but a systematic campaign to undermine the judiciary, to create a climate where judges are afraid to rule against the president because they know they will be targeted for attack. The question of whether the judiciary can withstand this campaign is the central question of our time, because the answer will determine whether the United States remains a constitutional democracy or becomes something else entirely. The courts have so far continued to function, to issue rulings based on the law, and to check executive power when the law requires it. But the cumulative effect of the attacks is taking a toll, and there are concerns that judges may become more cautious in ruling against the president for fear of reprisals. Roberts' statement is an attempt to push back against that dynamic, to remind judges that they have the support of the Chief Justice, and that they should not be intimidated by political attacks. The ultimate outcome of this constitutional confrontation will depend on whether the institutions that are being attacked have the strength to resist, whether judges will continue to rule based on the law despite the threats, whether Congress will step up to defend the judiciary, and whether the public will support the institutions that protect their rights. Chief Justice Roberts has done his part by speaking out, but the rest of the constitutional system must do its part as well, because the survival of American democracy depends on whether the separation of powers can withstand an assault from a president who does not believe in constitutional limits on his power. This is the moment of truth, the test of whether the constitutional system can defend itself, and the outcome will determine the future of American government for generations to come.